Greetings. This is the Employment Law class, and we are diving into Chapter 2, the Employment Law Toolkit. What this chapter is going to do is help you to understand legal terminology. Legal terminology is unique to the law. When we talk about something that is reasonable, what is reasonable within the confines of the law is not necessarily reasonable in how we would use the terminology in the parlance, be a reasonable person kind of thing. So there are certain terminologies that matter in the context of law, and it is also really important for you to understand how to understand citations and how to read those citations. The other things that we're going to address in this chapter are things like employment at will and some basic terminology regarding disparate impact and disparate treatment. And again, these should be a review for you if you've had your survey HR courses or your survey IO psychology courses. But it is important that we're all on the same page and we understand what we mean by disparate impact and disparate treatment. And ensure that we've got all, the same common language that we're using and understanding it. So let's start with our learning objectives. We have 9 different learning objectives for this chapter. There's a lot to cover, particularly in terms of the skills that we want you to develop in terms of being able to read and understand legal cases. So that's the first learning objective, understanding how to read and digest legal cases and citations. Again, it's very unique citation method, very different than APA or other formats that we typically use as we write papers and do research. Number 2, explain and distinguish the concepts of stare decisis and precedent. So what do this term mean in terms of how it impacts case law and how we interpret case law? For example, which law has supremacy in terms of where there's conflicts. So would a Supreme Court ruling overturn a state ruling, etc., those sorts of things. We want to be able to, in the third objective, evaluate whether or not an employee is an at-will employee. And most states are at will. There's a few that are not, but generally speaking, we need to know whether or not someone is at will, because that gives us a lot more freedom in being able to let somebody go if they are at will. Number four, determining if an at-will employee has sufficient basis for a wrongful discharge. Now, you would think, being at will, that there would be no circumstances where an at-will employee could say, this was a wrongful discharge and therefore, I want to sue. But there are situations and there are cases where that actually happens. So learning objective 5, recognize and explain at least 3 exceptions to employment at will. If you recall, the 4th learning objective is, are there circumstances where there is a sufficient basis to claim wrongful discharge for someone who's employed at will? And this is a great example of that. Those 3 exceptions have an impact on whether or not someone who is even at will may still have a case for an inappropriate firing or a wrongful discharge. Number 6, distinguish between disparate impact and disparate treatment discrimination claims. Disparate treatment, we know, is purposeful discrimination against an individual because of their membership in a protected class. And disparate impact is the unintended consequence on a class of people, a group of people, to say that we are having an unintended impact on this group, and therefore this may be a form of unintended discrimination, or it's an adverse impact or a disparate impact. So we're having an unintended impact on that group. I like to use the term adverse impact over disparate impact. It helps to differentiate it in the heads of people who are trying to memorize the difference between the two, right? Disparate treatment, I treat someone differently, and that's embedded in the word. Disparate meaning different, treatment meaning I purposefully am treating somebody in a certain way. Versus adverse impact means I have an unintended or adverse impact, a negative unintended impact on someone, and that doesn't have any intentionality behind it. The next learning goal is provide several bases for employer defenses to employment discrimination claims. So what are the criteria that an employer can use when they are being charged with discrimination? What are the facts that they need to take into account? Number 8, determine if there is sufficient basis for a retaliation claim by an employee. And oftentimes, if an employee is a good employee and they make a complaint about the organization or people in the organization, and suddenly we may see they have a whole series of negative retaliatory behaviors on the part of the employer for them standing up and complaining about something. And I had a circumstance like that myself when I accused somebody of sexual harassment, and I won some of my claims, but then the person tried to retaliate against me for raising those claims, and he was trying to sue me and ruin my career. So we got that all worked out. Of course, he lost, but retaliation can be pretty insidious. Lastly, we want to identify sources for further legal information and resources. So we want to make sure you're aware of where you can get legal information and resources if you have any questions about any of the cases or any of the terminology that's used in this textbook. So how do we go about reading cases? And the term that you want to remember is stare decisis, stand by a decision, and also the term legal precedent. And basically what that means is courts are going to look at prior court cases where there are similar facts and similar issues. And by looking at previous cases and seeing how things were ruled in the past, you can determine where there is similarity in the way that we interpret some of the facts, or where there may be some differences that may actually cause the law to be interpreted slightly different. Like, so you can have two cases that may have one difference in fact between them, and suddenly you go from what could have been discrimination, but because they didn't have this particular issue involved in this case, this new bit of information may now mean that this person was not guilty of those issues. And so the point I'm trying to get at here is we want to make sure that our interpretation of the laws are stable. They're not going to stay the same because the law is sort of living and breathing like anything else. It's an entity that grows and changes and morphs over time as we come to understand facts and information and science and things like that more often. So, terminology changes, interpretations change over time. So we use stare decisis to come up with what we call our legal precedent. So when we've got, a previous decision that people agreed with, then the legal precedent is in place that certain things will always hold the way that they're interpreted of a law. The more that a law is challenged and it doesn't get overturned, the stronger that law is and the stronger that legal precedent is. When we record opinions, typically you'll see the judges or the justices, depending on whether you're talking about lower or upper court decisions. You may see majority decision. You might see a concurrence where somebody says, I agree with the conclusion, but I disagree with the applicable law or the way that we interpret the applicable law. So you might have a variation in the way someone interprets that. So it's a concurrent opinion, and it may be in agreement with the majority, but they may have a difference in the way that they think about how to interpret it. And a dissent is someone who disagrees. And so, a justice could write, even though the majority ruled for this, I'm going to dissent and say this shouldn't be what occurs. And the interesting thing is, as we'll get into talking about mixed motives cases, we'll see how a dissent really changed the way we interpret mixed motive cases. And that's sort of the evolution of, the way the law, and the courts work. When we have a dissent, it then sometimes becomes an impetus for Congress to change the law to address the gap that was part of that dissent. So there's all sorts of interesting things that can happen there. Federal government and states have separate but parallel court systems. Now, the Supreme Court will rule on constitutional issues and federal laws. States will rule about state constitutions and state laws. Now, if a state law appears to be violating a federal law or a U.S. constitutional interpretation, then oftentimes state laws could be challenged in federal courts. But by and large, state laws and federal laws have their own parallel systems, and it usually starts with a trial court. Then there's a court of appeals, and then a Supreme Court. And so the Court of Appeals in the United States are based on regions and districts. And so you'll see District 7 or something along that line, which is actually Illinois and Indiana and Wisconsin, I believe. I don't know if it's anything more than that, but I believe it's those three states. And that district covers all the federal cases that happens, and they do the appeals for those in this particular region. So as I noted previously, there is interplay between states and the federal court system. Again, for federal cases, the U.S. Supreme Court, their decisions are final. With the state Supreme Courts, their decisions are final on state laws. And again, as I said, if a state law is found to be violating the U.S. Constitution, then of course that can move to a federal court if need be. When courts interpret a statute, what would happen if they're interpreting it in a way that was not the intention of Congress? Well, basically that has happened on multiple occasions. And of course, the most recent example that I can think of that comes to mind is the 1964 and the 1991 Civil Rights Acts. Now, the 1964 Act talked about a way of interpreting the cases, and over time, through precedent and through different case law, and interpretations by different courts, the interpretation actually morphed away from what the original intention was of Congress, and the Civil Rights Act of 1991 straightened that up, and it made it clear that the initial intention of Congress, was within certain parameters. And we'll get into that detail as we start talking about the case a little bit more. But I just want you to be reminded of that there are times when the courts start to interpret stuff and it starts to take a left-hand or a right-hand turn in a way that wasn't necessarily intended when the law was written. And so it really requires Congress to say, nope, that court precedent is not what we were talking about. We're going to amend this law to make sure that this is clearer and more precise in the language that we use. And that's what happens often when language is not as precise as it could be or should be. Case information, typically for cases, they talks about the parties to the litigation. So you might see a case, let me find an example of one here in the book. Santa Fe Railway Company versus White. So one is the plaintiff, they're making the complaint. The other one is the defendant. They have to respond to the case. And so the person is the one with the complaint. The plaintiff is the person with the complaint. The defendant is the person who, had the behavior that is considered inappropriate and is being charged with whatever violation of law there is, whether it's civil or criminal. A citation is where the report can be found in terms of court names and dates. And so you have a really great list of items in chapter 2, pages 54 and 55 that talk about the U.S. Supreme Court reporter. And so that has a certain notation. So, for example, you might see a citation that says 72 U.S. 544, 2002. And what that means is in the U.S. Supreme Court Reporter, volume 72, it's case 544, and it is, or page 544, and it is a 2002 case. So it's very precise language. So you could pick out that book, go right to page 544, and you'd be able to find the case that you need in any legal online or hard copy legal textbook, right? So if you have a citation that reads F3D, what that means, it is the Federal Reporter, and it is the and you'll also see in parentheses the circuit that it was a part of. So if you see that and you see, it's a federal court and it's Ninth Circuit, so it's the Ninth Circuit Court of Appeals, and it has page numbers and volume numbers and things like that for you to be aware of, and the year. Another citation, if it says SDNY, we're talking about the U.S. District Court in the Southern District of New York. And so the SDNY tells you which district trial court that was a part of. What else? So outcomes. So the outcomes that can come from, for example, a Supreme Court ruling can be affirming the lower courts, right? So an appeals court or a Supreme Court decision can look back at the lower court and say, I affirm what you did. So I agree with you and we don't find anything different. We think your interpretation was correct. You can reverse it where you can say, nope, the lower courts had it wrong. You forgot this important aspect. And based on our advanced knowledge and interpretation of the law, we're going to reverse your ruling and we're going to rule for the other side. Or you can remand, and remand means you're going to give it back to the lower courts for them to work out some details because you may not have enough information, or you may feel like it's not within the realm of what you should be looking at. If the lower courts have missed something, you can make them go back and take a look at it. So they're going to further handle that, quote unquote, with remand. And as you noted here at the bottom, right, it says case opinions in the Bennett text heavily edited to exclude material not relevant to the course. There's a lot of legal stuff that you're not even going to get to touch on simply because we're only dealing with civil rights stuff and narrower areas of interpretation of the law. There are a wide variety of other options out there, but this textbook is just really not going to touch on that.